Hello all. So today is third session of our ongoing playlist, which is Law Journal, which carries 10 marks of theory as per existing syllabus till 30th June 2022 and 9 marks with effect from 1st July 2022. So in today's session we are going to discuss one of the very important interesting topic, which is tort, various principles of torts and their effect on valuation, property valuation. So this is the full syllabus of the law journal, which carries 10 marks or 9 marks as per IBBI syllabus. Indian legal system, government, laws of contract. These number 1, number 2 we have covered in session number 1. Laws of contract we have already covered in session number 2 at length. In today's session we are going to cover tort, and in subsequent session we will cover point number 5 to 12. So let us first understand what is tort. Tort is a French word which means wrong, and tortum is a Latin word which means twist. A tort is a civil wrong which is based on breach of a duty imposed by law. Tort law is based on the idea that everyone in our society has certain rights and everyone has the duty to respect the rights of others. The purpose of tort law is to enforce those rights and duties. So please note down this purpose of tort law, which is to enforce those civil rights and duties. I have certain rights for me and I have certain duties for you, towards you. So following are the main constituents of a tort. Wrongful act, there should be some legal damage, and there should be some legal remedy. If all these three main constituents are there in any act, then it can be defined as a tort. So these are the important principles of tort which you should remember from examination purpose. 1 mark theory question may come out of any of these 8 principles. First principle is principle of Damnum, Sine, Injuria, and Injuria, Sine, Damnum. Second principle is principle of vicarious liability. Third is principle of Volenti, non-fit injuria. Fourth is principle of negligence. Fifth is principle of nuisance. Sixth is principle of trespass to property. Seventh principle of tort is principle of reputation and privacy. And last and eighth principle is principle of strict liability and absolute liability. So at least 1 or 2 marks, sometimes 3 mark question may come out of any of these 3 principles. So first principle has 2 parts. So first part is principle of damnum sine injuria. So damnum sine injuria is a Latin word which means damages without legal injury. Please note down definition or meaning of this Latin word. It means damages without legal injury. This means that when there is an actual loss to plaintiff without infringement of his legal rights, no legal action can be taken against the defendant. Thus, damages without legal injury is not actionable in law of tort. Let us understand this principle with the help of an example. Because of opening of a new school in front of the old school and lower fees offered by the new school, students left the old school and joined the new school. This led to financial losses to the old school, but in this case the old school cannot sue the new school for the financial losses because there is no violation of legal rights of the plaintiff. So this is a classic example of this principle. Second part of first principle is principle of injuria sine damnum. Injuria sine damnum is also a Latin word which means legal injury without any damages. So in this case, in case of violation of legal rights of a plaintiff without any actual loss to him, he may file a suit against defendant. Let us understand with the help of an example. If returning officer at a polling booth stops an eligible voter to cast his vote, and even if the candidate to whom the voter would have casted the vote has won the election, that is, there is no loss caused because of not casting of his vote, the voter still has a legal right to sue the returning officer because his legal right to cast the vote was violated. Second principle of tort is principle of vicarious liability. What does that mean? A person is responsible for wrong acts of other provided the other has certain relationship with me, for example employee-employer relationship, and the wrongful act must be related to the relationship in certain ways, and the wrongful act must be done by employee during the cause of relationship, that is during employment. So all these three factors should get satisfied, conditions should get satisfied for application of this principle of vicarious liability. Let us understand with the help of an example. For example, employer's liability to the act of employee during the course of employment. Or second example is liability of partners for each other's tort. So these are examples of this principle of vicarious liability. Third principle of tort is principle of Volenti non-fit injuria. What does that mean? To one who volunteers, no harm is done. A person who even after knowing the risk voluntarily agree to take risk cannot ask for compensation for the injury caused by the act. Essential elements of it are voluntary. First of all, plaintiff should be voluntary and there should be agreement, that is express or implied. It can be either expressed agreement or implied agreement. We have already discussed these type of agreements in last session, session number 2. So there should be an agreement between plaintiff and defendant, and there should be a knowledge of risk. Plaintiff should have knowledge of all risk. So if all these three conditions are met, then this principle of Volenti non-fit injuria shall become applicable, and plaintiff cannot claim any legal recourse for the damages done to him. Let us understand with the help of an example. By participating in a football match, the player willingly consents to bear the risk that may arise in the normal course of the game. So if I am playing a football match, so I know that I may require to face some injury while playing the game. Next principle is principle of negligence. Negligence is said to have been committed when a person owes a duty of care towards someone and commits a breach of duty by failing to perform it, resulting in legal damage caused to the complainant. In other words, a tort of negligence is committed when a person is injured due to their responsibility of another towards another. The damage so caused must be an immediate cause of act of negligence and not a remote cause. Please note down this line. Essential elements of negligence are duty to take care, number 1. Number 2, breach of such duty. There should be some breach of that duty. And number 3, condition that must get satisfied is legal damage caused to the complainant due to breach of that duty. So all these 3 conditions should met in, and any question can come out of these slides. So example could be a doctor while performing an operation leaves a pair of scissors inside the stomach of a patient. That is an example of principle of negligence. Next principle is principle of nuisance. Nuisance is derived from French word nuire, which means to hurt or to annoy. Nuisance is an unlawful interference with a person's enjoyment of land. Please note down this definition of nuisance. Nuisance is an unlawful interference with a person's enjoyment of land or some rights over or in connection with it, or some rights over the land or in connection with the land. There are 2 types of nuisances: public nuisance and private nuisance. Sometimes question come out of it only also. So what is public nuisance? Public nuisance is causing inconvenience and annoyance to the public at large, not to a specific person. Examples are fireworks in street, construction of a structure in middle of a public way, obstructing the passage of public, etc. And private nuisance is causing inconvenience and annoyance to a specific person or a set of people. For example, destruction of crop of an individual, a poisonous dog of a person enters into neighbor's premises and causes destruction. This is another example of private nuisance under principle of nuisance. Sixth principle is principle of trespass to property. Trespass of property is an unjustifiable physical encroachment. Please note down the words which I have highlighted and underlined. So it is an unjustifiable physical encroachment of land of one person by another. If a person directly enters upon another person's land without permission, or remain upon the land, or places any object on the land, he is said to have committed tort of trespass to land. So there are following ways through which this trespass to land can occur: enter upon land, trespass to airspace, this is also kind of trespassing, and third is trespass to the ground beneath the surface. So it is not on the land, under the land, and in the air also. So there is one more terminology which is called continuing trespass. It occurs when even after withdrawal of permission by the property owner, someone keeps continuing on the land. He or she can continue to use that land or continue to keep an object on the piece of land. So that is the definition of continuing trespass. So these are the important elements of encroachment. Theory question may come out of it. So for an act of trespass to be actionable, it is necessary that the land in which the trespass has been committed must be in direct possession of the plaintiff, number one. Encroachment must be done due to some direct act of defendant and not indirect act or remote act. This second element, important element. And third important element is, even if the defendant has no intention to trespass but commits a such act, this amounts to trespass and legal actionable. Please note down this small difference between nuisance and encroachment. There is a hairline difference between these two terminologies, and sometimes 1 mark theory question come out of this only. So encroachment is nothing but interference on the property, number one, and nuisance is nothing but interference with the right. So this is the hairline difference. Interference with the right to enjoy the property, this is nuisance, and encroachment is interference with the property. So I repeat, encroachment is interference of property and nuisance is interference of right on the property. This is the hairline difference. Seventh principle is principle of reputation and privacy. So defamation is a key word under this principle. Defamation means publishing false and defamatory statement about someone without any law or justification, which lowers reputation of the person in the eyes of right-thinking member of the society. So defamation could be of two types. These two definitions please remember from examination perspective: libel and slander. So libel, defamation is nothing but written form of statement, for example cartoons, drawings, recordings, etc. And slander is oral form of statement of causing defamation. So these are the important elements of defamation. Statement must be published, statement must be false, statement must be defamatory, statement must refer to the plaintiff. Please remember all these four factors. Eighth and last principle is principle of strict liability and absolute liability. Please remember these two definitions. Theory mark question may come out of it also. So strict liability is nothing but at times a person is held responsible for doing a wrong even though there has been no negligence by him, no intention to do wrong, or even if he had taken necessary steps to prevent such a wrong from happening. So this is known as strict liability and is based on no fault theory. And what is absolute liability? It is a stricter form of strict liability. It is same to that of strict liability, but here the wrongdoers is held absolutely liable for the wrong acts without any defense. So there is no option of defense here, which is given to the wrongdoer, which are available under the rule of strict liability. So in case of strict liability, the defense option of defense to wrongdoer is available, but here it is not available. It is applicable to those people who are involved in hazardous or inherently dangerous activity whereby they become absolutely liable to pay full compensation. So these are the exceptions to strict liability. Escape of hazardous good was because of plaintiff's own consent, act of God, act of stranger, act done by any statutory authorities, default of plaintiff. So if any of these 5 activity happen, then these will not be covered under strict liability principle. So these these are the 3 important type of torts which affect valuation of a property. First is nuisance, second is trespass to property, and third is strict liability and absolute liability principles of tort. So that's all for today's session. Thank you for watching. So if you have not subscribed to the channel till now, please subscribe to it and click on bell icon so that you will be notified immediately after I upload next session. So in next session, we are going to discuss about law of arbitration and reconciliation. I'll also try to cover auction part in subsequent session in next session. So these 2 topics would be covered in next upcoming session. And thereafter we will cover law of evidence, salient feature of IBC, then Companies Act, Registered Valuer Act rules, Surface Act and Banking Regulation Act from examination perspective. Thank you.